A lot of times people have gone through divorce and they may either have made an agreement with regard to their custody and visitation, or the judge made a decision about how it was going to go. And time goes by and they find out that it just doesn't work anymore for them. If you and your ex are in agreement and want to change up your custody agreement, either the kids are going to go live with the other parent or we're just going to modify the visitation schedule. If you all are in agreement, you can absolutely always sit down, write out your agreement. You may want to go back to mediation and document it in a mediated settlement agreement. But once you've done that and come up with something that you both agree will work and document it, you can absolutely put that in an order and ask a judge to sign off on it. You do not have to go back through a whole custody battle. You don't have to go back through a trial. You can always agree, and the judge is going to do what the parents think are in the best interest of the children. If you can't come to agreements with regard to custody and visitation for your kids, you're going to end up in a mediation process. And mediation is a process where we're going to negotiate to try to come up with a resolution that both parties can live with. Typically, that is with a third party as your mediator. Often that's a lawyer, doesn't have to be, but that third party person is neutral. They have no skin in the game. They can't make you or your spouse or your ex-spouse do anything. They're just there to try to agreements. And the goal is to come up with an agreement that everybody can live with. Nobody is winning or losing. Nobody's getting everything that they want and the other person's not getting anything they want. Sometimes, in any negotiation, you're going to give a little to get a little. And so that is the ideal mediation. Again, getting in there and being reasonable, open to giving up a little to get something else that you want, to come up with a custom agreement that works best for you and ideally best for your kids. If you are preparing to go to court for a custody decision, you are going to really want to work with your lawyer about how to present yourself in the best way possible as looking out for your children's best interest. This is not the time to be focused on you. You want to focus on your kids and what's best for them. That's what the judge is going to want to see. So you're going to spend a lot of time with your lawyer talking about your kids, what their schedules are, what their needs are, how you meet those needs, and how you look out for their best interest. You are going to want to portray yourself as the good parent that you are and really help the judge see that. You won't have as much time as you would like. Ideally, it would be best if you could go in and the judge could see a day in the life of you and your kids, but you're going to have a short amount of time to present well and to present to the judge that you are the best parent, to be the primary parent, that you are going to look out for them in everything that they do, and you're going to work with the other parent. That's a really big thing that judges want to see, is that you are going to be cooperative and are going to be willing to co-parent with your kid's other parent. If you are causing problems, or if the judge thinks you're causing problems, that will go against you. In preparing for your custody trial, your lawyer is going to ask you for a lot of information, a lot of documents. Some things that will be important for you to show is pictures of your house, of activities that you do with your kids, activities that you help your kids participate in, to show that they're happy and healthy in the things that you do with them. You're also going to maybe want to talk to their teachers. You're going to want to get their grades and have that information for the judge to show that they're doing well in school, that they're adjusted well. If your kids have some anxiety issues, whether that's related to the divorce or not, if you've got them in counseling, maybe you want to bring the counselor to talk about how you're working to help your kids through a difficult time for whatever reason. So showing that you are the good parent, that you are interested in your children's lives and that you're looking out for their best interest encompasses a lot of those things, from their medical health to their mental and emotional health to their educational situation and just being well-rounded kids. The other thing that you are going to really want to show, and your lawyer will help you develop this, is to show how you try to get along with the kid's other parent. Doesn't mean you have to get along with them, because sometimes that may be difficult to do, especially if you've going through the divorce or if you've been through a divorce with that person and it's still not very amicable. But you need to show that you try, that you are giving information to the other parent, and that you are trying to work with them, and that you are not trying to stir the pot all the time. Everything that you can do to show the judge that you are the reasonable one, that you are looking out for your kid's best interest, that is going to go a long way in your custody battle. In Texas, a parenting plan is the plan for how much time each parent's going to spend with the kids and when and where that visitation is going to take place. The kids often are going to live primarily with one parent, and the other parent is going to have visitation. There's going to be a provision for how the kids go back and forth. That may be one parent picking up at the other parent's home and dropping back off there, or maybe you split the time and you pick up at a midpoint. Often the kids will get dropped off at school and picked up at school. And that is really the best way to avoid conflict. If you are in a situation with your kid's other parent that you cannot get along with, that there's drama every time you see each other, the best option for avoiding that conflict is to have pick up and drop off at school, so you don't have to see them all the time. You drop the kids off when it's time for them to go to school. The other parent picks them up from school and maybe drops them back off. That reduces the amount of time you have to be with your ex, so that that conflict is diminished. When you get divorced, there's a geographic restriction in place. That means that the parent that the kids live with primarily, that their home is the kid's official residence, that parent has to live within a certain area. And usually that's the county that you filed your divorce in, the county that you were living in at the time you got divorced. And sometimes it's the counties surrounding that. So it can be a very small area or a fairly big area. In the Houston area, if you have, say, Harris County, which is where Houston is, and the contiguous counties surrounding it, that's a pretty big area. If you live in a smaller county, it may be a smaller area. But the kids are generally going to live in that area, and that's designed to help both parents be able to see the kids as much as they can. If one parent moves away, moves farther away, then we're going to have different rules about what the possession schedule is. In fact, even in the standard possession order in Texas, there's a provision that says if one parent moves more than 100 miles away, then we have options for changing up the visitation arrangement, because logistically it's just a lot harder. If one parent does move further away, there may be changes in the possession schedule to include the ability for the children to fly. Depending on their ages, that may involve requiring that they have someone to supervise them while they're on a flight. You can pay for a flight attendant to monitor and make sure the kids get from point A to point B, and make sure that they get to the other parent. There may be provisions in your custody arrangement about who's going to pay for the costs if kids need to travel to be with the other parent. But certainly, the further the parents live apart, the more difficult it can be to manage those possession schedules. Because we're looking out for the kids' best interest, the goal of the court system is to make sure that your kids have a stable environment. they are going to want to know that your kids have a primary residence, that they have one place that they call home. They may go back and forth to the other parent and have two homes, but they want to make it stable for the kids. The kids didn't cause your divorce. This is something between you and your spouse. And so helping your kids get through your divorce, helping them get through their childhood in a safe way is something that the courts really want to make sure happens. And so if we have parents moving far apart, that makes it more difficult. And honestly, the court is going to say, well, if one parent moves, then that parent is the one that's going to have to take up the slack and make it work. The kids need to have a stable environment, and we want the kids to be around both parents. We want both parents to be involved in their lives, but the kids should have a bubble of protection. So if one parent moves away, then they're the ones that are going to have to adjust, not the kids. When you have a geographic restriction, that is for the benefit of the parent who has visitation. And if that parent picks up and moves far away, then that lifts that geographic restriction and allows the parent who was limited, who had to stay within a certain area, that parent can now move wherever they want to. So be cautious about that. If you are moving away from your children and that may cause that geographic restriction to lift, your ex-spouse could pick up and move somewhere else and move even further from the kids. So something to definitely think about if you are considering whether to move further away from your children.